and welcome to the Leavitt and GBS webinar on Are You Prepared for a DOL Audit? My name is Lisa Klinger. I'm one of the benefits attorneys at the Leavitt Group and GBS, and today is January 28, 2015. Okay, so let's see if I can get my computer to move forward. As the initial announcement told you, all attendees are in listen-only mode, and if you want to ask a question, please type it in the box, which I believe should be on the right-hand side of your screen. I'll try to check for questions every so often, or I'll get through it and then answer questions at the end. Actually, today we have a very full presentation, so I may wait till the end for questions. If you do not already have a copy of today's PowerPoint and you want one, please request a copy from the Leavitt or GBS advisor who sent you the invitation to this seminar or webinar. I know they'll want to follow up with you. Also, we do offer free client webinars for clients and prospects on various healthcare reform and benefits topics. We are setting the dates for February through June, and we'll send out a notice on that soon. So we'll get started on today's topic. Let's see, I'm having some technical difficulties. There we go. So I've got a lot to cover today. I'm going to try to just spend a minute or a few on each slide, and then you'll have the printout, or if you want other materials that we have, or if you have questions, ask me. Today's agenda, I'm going to do a short overview of the different government agencies that audit employee benefit plans. Then I'm focusing specifically on Department of Labor audits of group health plans. So I'm going to go over, I'll show you the DOL letter and their attachment A, their checklist of the documents they request, and I'll quickly go over what those documents are and why the DOL requests them, and what you should be keeping a file of in case you're audited, and also just because you should have it. And as part of that, I'll talk about the ERISA requirements on group health plans. And then I'll also talk about what you should do now and what to do if you do get a DOL audit letter, and I'll briefly go over some of the steps to the DOL audit. So I know that for many of you, maybe one of your New Year's resolutions was to make sure your employee benefit plans are compliant. Just in case you get audited, because you've certainly been hearing about the DOL audits. So your chances of getting audited are greater this year than in prior years, and one of our focuses this year at Leavitt and GBS is to really have a compliance campaign and make sure that our clients are in compliance in case they're audited or even if they're not. So this is a DOL audit preparation flow chart that we've put together, and we'll be sending it out as a separate page, and then following up, and then I'll have attachments for the different yes and no answers. So it's really looking at, are you an employer who's subject to ERISA in step 1? Is your plan subject to ERISA in step 2? Then step 3, are there some ERISA provisions that your plan is exempt from? Step 4 is do a self-audit, and step 5 is gather the documents and materials that you might need from the DOL audit list that you don't currently have, or actions that you're not currently doing. So a little bit on employee benefit plan compliance and the agencies that have jurisdictions over different aspects of benefit plans. The 4 main agencies would be the Treasury or IRS, HHS, Health and Human Services, and CMS, the Centers for Medicare and Medicaid Services. The third one would be state insurance departments, but they really have jurisdiction over the insurance companies, so that impacts the requirements that in your insured policies, but they don't have jurisdiction over employer plan sponsors generally. And then the DOL or Department of Labor, and EBSA is the Employee Benefit Security Administration. So as I said, this PowerPoint really only addresses DOL audits. there are other actions you need to take and other documents you need to keep that the DOL doesn't have jurisdiction over. For example, the IRS has jurisdiction over tax treatment of employee benefits, like the non-discrimination rules or cafeteria plans, also over various Affordable Care Act issues, such as the large employer mandate penalty under IRC Section 4980H. And you often hear that referred to as the 4980H A and B penalties. So those are other areas of compliance, for example, that wouldn't be covered in a DOL audit, but that you would still need to be sure you're compliant with. Or, for example, HHS and CMS have jurisdiction over HIPAA privacy and security, and also over Affordable Care Act insurance market reforms, and over the Public Health Service Act and plans and employers that aren't subject to ERISA, and I'll talk about those in just a minute, but are subject to the Public Health Service Act. So another question is, what employers are subject to ERISA and what benefit plans are subject to ERISA? And ERISA Section 4A says that ERISA Title I applies to any employee welfare benefit plan if it's established or maintained by an employer engaged in commerce or in an industry affecting activities in commerce, or by an employee organization that represents employees, like a union. But so that includes both private, for-profit, and not-for-profit employers. There are several exemptions of employers who are not subject to ERISA and plans that are not subject to ERISA, and that's non-federal government entities like cities, counties, public schools, and churches and Indian tribal governments. But the government entities and churches that are subject to, and Indian tribes subject to the Public Health Service Act, the PHSA, and most of the, or many of the provisions in the Affordable Care Act and HIPAA that amend ERISA and or the Internal Revenue Code also amend the Public Health Service Act. So many of the same provisions apply to those other, to churches or governmental entities, group health plans, even though it wouldn't be subject to a Department of Labor audit. It would be subject to, they might be subject to an IRS audit. So the next issue is, well, who has to comply with ERISA? What is the, who's the Department of Labor targeting if they do an audit? The two entities are basically plan administrators and plan fiduciaries. The plan administrator is the plan sponsor unless there's a written delegation to another party. But the entities that are not the plan administrator under ERISA, like in quotes or capital P, capital A, would be the insurance broker, the insurance carrier. Usually if you have a third-party administrator, if you have a self-insured plan, or if you have a health FSA, they're probably the claims administrator. And you should look at your service agreement with them, but probably it specifies that they're not the plan administrator under ERISA, they're the claims administrator. And your COBRA administrator is also not the claims administrator. So a plan administrator has to comply with various ERISA requirements, like the reporting and disclosure requirements. The plan administrator would adjudicate claims unless you have a claims administrator who's specifically doing that. And the plan administrator would ensure that the plan complies with ERISA and that it provides the mandated benefits and complies with ERISA procedures. And again, that's probably the plan sponsor, or you may have a plan administrative committee. That's the plan administrator. The second category is fiduciaries. And fiduciaries are individuals or entities who have control over the management and administration of the plan and plan assets. And that would be more than just the plan administrators. So for an insured plan, or probably for many self-insured group health plans, if they're paid out of employer assets, there might not be any plan assets. But like in a retirement plan, there would be plan assets. but there are still fiduciaries of a group health plan because they control the management and administration of the plan. And there are certain, and fiduciaries might be the VP of benefits or HR, or it could be also other outside third parties if they're investment advisors, for example, but that would be on a retirement plan. Fiduciary duties, the main fiduciary duty is that fiduciaries have to act solely in the interest of plan participants and beneficiaries, and they have to act for the exclusive purpose of providing benefits and defraying reasonable administrative expenses. And if they don't do that, then that's a breach of fiduciary duty. And in a DOL audit, the one thing the Department of Labor is looking for is whether there's been a breach of fiduciary duty. They're also looking at whether your plan documents appear to be compliant on their face, whether your plan is compliant on its face. And they're looking also at whether the plan is compliant in operation. And part of that operation is whether fiduciaries have acted in the way that they're supposed to, or whether there's been a breach of fiduciary duty. And I'll talk a little bit more about that later. Also, though, fiduciaries have to act with the care, skill, prudence, and diligence of a knowledgeable and prudent fiduciary. And there are two different standards. There's the reasonable person standard and the reasonable fiduciary standard. And the reasonable person standard is a lower standard that people have to meet, but this is the higher standard of the prudent fiduciary. And what that means is if you're a plan fiduciary, you need to know what you need to be doing. For example, you need to be sure that the plan is administered in accordance with the plan documents and in accordance and in compliance with ERISA. And if you don't know how to do some of those things, you need to take the action to be sure that you are knowledgeable as a fiduciary, that you know what a prudent fiduciary would know, not just a reasonable person who wouldn't necessarily have some of that level of knowledge. And a lot of the white papers and the articles that we write will help you with that. And also we have, for example, a DOL audit kit. I don't know what's going on with my computer. We have a DOL audit kit with a list of what you need to have, and we also have a longer compliance checklist that lists more than just the Department of Labor requirements. So, what plans are subject to ERISA? Well, for one thing, it's group health plans and group health and welfare plans and retirement plans. But again, I'm just focusing on the health and welfare plans in this presentation. So that would include things like your medical and prescription drug plan, wellness plans, dental and vision plans, group life and AD&D, group disability, and voluntary benefits or worksite benefits are often are subject to ERISA. There is an exception under ERISA if they meet certain requirements, which I'm not going to go through here, but when you're audited, if there's a DOL audit, they will be looking at plans that are subject to ERISA. And for example, plans that are not subject to ERISA would be workers' comp plans or plans set up to comply with state laws like workers' compensation or unemployment, or plans that are primarily for people who live outside of the United States. So let me talk a little bit about DOL enforcement and how likely is it that you would end up being audited, and then I'll talk about what things the DOL is looking for if you are audited, what things they request. The Department of Labor has broad investigation powers, and that's under ERISA Section 504. So they have the power to investigate whether any person has violated or is about to violate any provision of ERISA Title I or any regulation issued under that. And they don't even need reasonable cause to believe a particular violation exists. They can investigate or require records even if they don't have reasonable cause. And sometimes what happens is if someone files a complaint, if an ERISA plan participant files a complaint, then the department will start an investigation, which just means they will get the complainant side of the issue, and then they'll call you, the plan sponsor, and ask for your version of what happened or what you're doing, And that's not an audit, but sometimes an investigation will trigger an audit, and then they'll come out and audit. So how likely is it your plan will be audited? Well, the DOL has authority over millions of plans, and 2.8 million health plans in 2014. And in 2014, the statistics from the DOL website, there were 3,928 civil investigations, so not criminal, but just civil investigations, and 2,500 of those, over 2,500, resulted in monetary penalties for plans or other corrective action, where they, and I'll talk about that later in the presentation on the DOL audits, but monetary penalties and other corrective action. So that's not a high percentage out of 2.8 million, but still, the DOL does have an audit program, and they're auditing or intending to audit and have started auditing for compliance with the Affordable Care Act as well as general HIPAA requirements. And what are the reasons that the Department of Labor might investigate or audit your plan rather than someone else's? Well, the main areas they look at if there are participant complaints, and as I said, if there's an investigation and that leads the DOL to conclude that maybe there's there's something that you're doing that's not in the plan, isn't in compliance, that it wasn't just an individual issue with a benefit issue, but that the plan isn't complying with some provisions. Or there might be information in the 5500 that the DOL that indicates that there might be some non-compliance. The Department of Labor and the other offices also have specific national office initiatives, like they're auditing for PPACA, Affordable Care Act compliance now. Or there might be news stories and tips of something that's happening, that's an issue that they might want to investigate. And as for an example on that, one of the issues when the Affordable Care Act was in the last few years, and some employers, or mostly owners of some, usually restaurant chains, were saying into the press things like, well, I'm just going to keep employees' hours down so that they don't qualify for benefits, and there might be a question as to whether that would be a violation under ERISA, that they would be preventing them from getting benefits that they would have been eligible for. So this is the DOL audit letter. This is just the first page of it, but if you might have seen one of these, or just so you know what it looks like, it just says we're conducting an investigation and we have authority, you know, under 504, and we're going to look at the plan for purpose of determining whether it's complying with ERISA, blah, 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 blah. So that's just what the letter looks like. And then attached to the letter, there's this attachment A, which is actually 4 pages long, but this is just the first page of it here. And don't worry that you can't read it. It just lists, I'm going to go through a lot of these items in more detail, but it lists the documents that the Department of Labor is requesting for the audit. And some of the things may not apply. If they don't apply, you just tell them that. But these are the things that you should be sure that you're keeping track of now and that you do have. So here's kind of the first part of it. You might want to keep a separate electronic file of some of these documents if you don't already have them. Some of them you may be keeping you know, in your group health plan file or electronically, but some of them might be things that, like corporate resolutions relating to the plan, you might not be keeping in a file, but you might want to start just an electronic file and make sure that you have all these things in it. So let me talk about some of these. The ERISA plan document requirement. ERISA does require that a plan be established and maintained pursuant to a written instrument, the plan document. So that's why the Department of Labor is requesting a copy of the plan document. And if you don't have a separate plan document, you can use a wraparound plan document. Because what happens with insured benefits is often employers don't have a separate plan document. They have the insurance contracts and the benefit booklet and the summary plan descriptions. And so you want to have a wraparound document that wraps around the other written materials and says this, along with the other written materials, is the plan document for ERISA purposes. Now, what the most courts have said in the past is if there's not a separate written plan document, then we'll just look at the written documents that exist. But a wrap document, you can specify certain things that may not be covered in the other documents. The plan document should be formally adopted. It doesn't have to be distributed to participants unless they request a copy of it, and then it should be just provided within 30 days. So in your file, you want to have a copy of the plan documents and amendments, and if people requested a copy, maybe note that that you gave that to them. Also, if you don't, a note about the trust. A trust is used to hold plan assets. So if you have an insured plan, or even most clients who are self-insured and just pay benefits out of employer assets, you won't have a separate trust. So if the Department of Labor asks for that, you just need to note in your response that you don't have a separate, there isn't a trust. And the plan document, if what the DOL is looking for, it should specify who's the plan administrator, who are the named fiduciaries, how the plan is funded, what are the plan amendment and termination procedures, what are the administrative procedures, and then, of course, the required provisions. It's going to specify what the benefits are, what the exclusions are, who's eligible, what are the ERISA requirements, and other, COBRA, HIPAA, Affordable Care Act rules. Some common plan documentation issues that come up on audits is sometimes there are arrangements that don't have documents. Sometimes, for example, premium-only plans, you should have a plan document, or flex plans, health reimbursement accounts, employee assistance plans. Another question is whether a carrier's certificate of coverage is a plan for ERISA purposes. And as I said, it's probably not really. It would be better to have a wrap document, but if you don't have that, the Department of Labor and the courts have generally looked at, okay, what written documents do you have, and that's the plan. But if you just have the certificate of coverage or benefits book, that may not have all the ERISA required information. And also, even if you have a self-insured plan, make sure that you have updated documentation, because your TPA or your attorney should have restated or amended your plan for the Affordable Care Act in the last year and few years. The second area that the Department of Labor, on the Department of Labor list, is summary plan descriptions, or SPDs, and SMMs, summary of material modification, and SMRs, summary of material reductions. So the first page, the SPD requirement, ERISA 102, plan administrators have to give participants SPDs that tell them about their eligibility and benefits and their rights and obligations under the plan, and it should be reasonably calculated to be understood by the average plan participant. So like in your file, you should keep a copy of SPDs or wrap SPDs, or the foreign language notice, which I'll talk about in just a sec. But note that the plan administrator is the one who's required to give the SPD. So that could be different from the insurance company's benefit booklet. A lot of it is the same information. There's a big overlap, but there might be additional information. And some of it the carriers include in their booklets now, like the ERISA rights language. Also, the foreign translation, the foreign language translation or notice. The requirement is that if 10% of the county population is literate in the same non-English language, then plans have to provide certain notices either in that language, or they have to provide a notice stating that language assistance is available. And the SPD is one of those documents, and SMMs and benefit denials or responses. And if you're insured, your carrier is probably doing this, but you also might want to make sure that you have it available for the SPD, because the carrier wouldn't necessarily have that. The four languages are Spanish, Chinese, Tagalog, and Navajo. And we do have an article on the Health Reform Updates website and the GBS article that explain that where there's a link to what counties need what language assistance. Okay, the next area is the SMMs and SMRs. The easy way I say you can know the difference is when you say SMM, you smile because the corners of your mouth go up. And when you say SMR, it's smir, and it's a frown. And the SMR is about a material reduction in benefits. So that's why you're frowning. And the SMM, you're smiling because it's if there are material or significant changes to the SPD information. And that could be a change of carrier or benefits or changes in rates or changes in cost-sharing reductions or amounts, or it could be additional exclusions. And legally, you need to provide the SMM within 210 days after the end of the plan year, although I'm sure that most employers are providing it long before that, because really your annual notice of changes to the plan, that's probably part of your enrollment packet, that might be an SMM or an SMR. And often you might be giving it out as a cover letter, so you might also want to add at the top of that, this is also a summary of material modifications. The SMR, the SMR, has to be provided within 60 days after a material reduction in health benefits is adopted, even if it's not effective until later. So I think for a lot of employers, it's not adopted earlier and then effective later. It's usually adopted kind of about the same time or shortly before it becomes effective. But that time frame is something to keep in mind. And in your file, you want to keep copies of the SMMs, the SMRs, maybe the enrollment packet cover letters, and the dates that those went out. Some common SPD issues, benefit booklets provided by carriers are usually not exactly SPDs. They don't have all the required information, so you might want to have a wrap SPD or additional information. Usually some of the benefits booklets don't accurately state the employer's eligibility requirements. So it might just say as specified by the employer, and also if you have different lines of coverage, there might be different eligibility requirements for the different ones. So you do need some language in there, maybe in your wrap SPD, and you might, especially if you have variable hour employees, and now under the Affordable Care Act, you're going to use a look-back measurement period to determine when they're eligible. You don't have to have all the detailed language in that, but you need to have some explanation of it and then maybe refer to an outside policy or procedure. And we do have a sample policy or procedure that our clients can use, and you can just fill in the blanks and delete the part that you don't want. I make it sound a little easier than it is, but it is something that you might want to use to document what your eligibility requirements are under the Affordable Care Act. Okay, so penalties for failing to disclose the summary plan description or SMM. There's no specific dollar amount or daily penalty, but it is one of the things that plan fiduciaries and plan administrators should be doing. So it could be a general violation, also, or it could be a breach of fiduciary duty not to be distributing the eligibility information and the plan information. There are specific penalties for failure to give a participant or beneficiary the plan information that they want within 30 days if they provide a written request, like the plan document, or failure to give HIPAA certifications, failure to inform of COBRA rights, failure to meet other COBRA requirements, and that's $100 and $110 a day. And there's an IRS form 8928 for self-reporting if you're not complying with COBRA and HIPAA. And so there's a penalty for not using the IRS form 8928, which I think probably most employers are not using, even if they are not in compliance. However, again, the IRS form 8928 would be an issue on an IRS audit rather than a Department of Labor audit. This slide, I'm not going to go through this matrix, but it does show when is disclosure required for a new plan, the SPD, or an existing plan, or the SMR, or the revised SPD. So I wanted people to have this information. It's something to look at, and if you're keeping in your file when you've put out SPDs or SMMs or SMRs, just be sure and document that it meets these time frames. Another thing that's not in that the DOL will be asking about, although it wasn't in some of their prior lists, is the SBC, or Summary of Benefits and Coverage. And this is, you probably recognize this, this is the blank template. There were just regulations issued in December that shortens it's currently 4 pages, two-sided, which is 8 pages, and the regulations will shorten it to 2.5 pages. So this is the slightly shorter version, and this is the sample version from the DOL website that's filled in. So it would be a good idea in your file to keep a copy of those, the SBCs, as well as the SPDs and SMMs and SMRs. So what are the documentation requirements, the document retention requirements? Well, the basic rule is that you should keep employee benefit plan documents and things that are needed to substantiate a 5500 filing for 6 years after the date of the filing, or after if there was a resolution or plan amendment. It's generally recommended that you keep documentation for 7 to 8 years, because employers often file an extension for the 5500. So in your folder, you probably want to keep signed plan documents and amendments, board resolutions, all the things we're talking about. And you probably want to keep them for 6 years, and maybe 7 or 8 years. And keep them in a format that can be easily retrieved, because if the DOL audits, they're going to go back probably 5 years, and they could go back farther than that. So you don't want it to be in boxes that are stored away when you can't reach them. You can't get to them easily. The next issue is just on electronic distribution. So the DOL regulations do allow plans to provide certain documents electronically, like SPDs, SMMs, the notices listed here. And there are 3 safe harbor criteria. It does have to be, basically you have to provide it in a way that you're trying to ensure that people actually receive it. So for example, if you send it by email, you could send it return receipt requested, or by first-class mail for that matter. It has to, even if you send it electronically, it has to comply with the ERISA style, format, and content requirements. And you, at the time that you send it electronically, you need to, for example, you need to tell participants what's being provided, what's the significance of the document, and that they have a right to a paper copy of the document. So you might send an email, and in the subject line you would say important 2015 SPD link included. And then the electronic distribution, there are the 3 different categories or scenarios. For participants who have work-related computer access, you can provide the SPD, and you don't have to get written consent before providing it if those 3 criteria are met that were just listed on the prior page. It used to be required that employees had to be able to print out the documents at work, not just access them, but that's no longer required. The second category is if you have participants who don't routinely use the computer system at work, then you can only send the documents electronically if those individuals affirmatively consent in writing to receive it electronically, and they have to provide an email address, and they have to do that before you send out the documents. So you might send the SPDs or other documents electronically to the employees in that first category, and then send paper copies to others. So just because not everybody is in the first category doesn't mean you have to send everything by paper. But on a DOL audit, they are going to want to know that if you sent documents electronically, did you send them electronically only to people who are in that first category, or if they're in the second category, consented to receive them electronically beforehand? So if you do have that, you should keep those written consents that you received. And we have some sample written consent forms that you can request from your Leavitt or GBS advisor if that's something you want. The next area is Form 5500s. If there's a DOL audit, they're always going to ask for the 5500s, but those wouldn't necessarily apply for small plans. If you have fewer than 100 participants on the first day of the plan year. Church plans, excluded government plans, and that the 5500 is due by the end of the 7th month after the end of the plan year. You can get a 2.5-month extension by filing a Form 5558, but you have to file it by the due date of the 5500. And so in your file, you want to have copies of your Forms 5500s, your 5558 if you file an extension, the proof that you filed on time, and any attachments to the forms. If you are a late filer or a non-filer, if you find that there are some years when you should have filed and you didn't, there is the Delinquent Filer Voluntary Compliance Program, DFVC, but you can only use that prior to audit. So once the DOL comes to audit you, unless you can jump in there and show that you started it beforehand, you won't be able to use it. The next item the DOL asks about is the summary annual report, which is just the 5500 is an annual report. So this is a summary of the 5500. There is a prescribed format in the ERISA regulations themselves, and that you should provide to plan participants by the 60th day after the 5500 is filed. And it's required for a health plan that filed a 5500 if the Schedule A was required, or if the plan is funded through a trust. So again, you want in your file, you want to keep the SAR and the evidence of the dates it was sent and to whom it was sent. And that's something that probably whoever prepares your 5500 probably gives you a copy of that SAR, and you, the plan sponsor, need to send that out. And that, again, is one of the things that could be sent electronically to employees, participants who have the electronic access at work. This is continuing with the list of things that was on the DOL Attachment A. So, for example, the documents on plan fiduciaries, trustees, and committee members. The first thing that they ask for is documents identifying the Social Security numbers, home addresses, phone numbers of plan trustees and plan administrative committee members. And we've often found that employers don't have Social Security numbers. There may not be a plan administrative committee if you just have an insured plan. So it may be if you have plan trustees, which you probably don't have that if you don't have a trust. And a list of parties in interest, all group applications and contracts for health benefits. You probably want to keep, and all for self-insured plans, any contracts with your TPAs or your stop-loss carrier. So again, in your file, you want to have an electronic folder, and it might be plan committee and fiduciaries. There might not be much in there, but then you also would have, copies of your applications for group insurance or contracts with TPAs. The next group of items in the DOL requests are board minutes, corporate resolutions, fidelity bonds, and insurance. So in your file, you might want to have a separate subcommittee for your company board resolutions, and if there's a plan committee, a separate folder for that. And you don't have to keep all the minutes from your corporate meetings, but you want to keep the minutes or the resolutions that apply to the plan. So if the board adopts a new plan, maybe a new HRA or high deductible health plan and HSA, you probably want to get a copy of that resolution and keep it in your group health plan file, because that's the kind of thing that the DOL will be asking for. And you might be audited in 2 years from now or 3 years from now, and your company might have adopted that plan 4 years ago. So just to make it easy on yourself, put those things in your electronic folder now. The fidelity bond is 10% of the total funds handled, a minimum of $1,000 and a maximum of $500,000 per plan official per plan. But you probably don't need it if your plan is unfunded, self-insured, and it's paid from employer assets, or if it's insured, unless there's some monies that plan officials are handling. Also, fiduciary liability insurance is not required, but many plans do purchase that because it insures the plan against losses that are caused by a breach of fiduciary duty. So if you do have that, you want to be sure you have a copy of that in your folder. The next group of things that the DOL requires: contracts for health insurance, contracts with third-party administrators, documents identifying all the business associates or service providers to the plan, other financial information, schedules of fees and commissions and compensation paid in connection with the plan. So that would be like Schedule A's or service agreements, and then invoices and payment records for the payment of expenses. And those might be things that are either, I would say, put them in your electronic folder or have a note as to where that information is. If it's in financial records, of the company, but have something that tells you where you would find that. Still continuing with Attachment A, employee enrollment packets, enrollment forms, plan costs and notices, documents showing the employer and employees' costs for the plan, and also the process for collecting premiums from active participants and from COBRA participants. And why is the DOL asking for these things? Well, maybe with the enrollment package, does it include the required notices, like the Women's Health and Cancer Rights Act or HIPAA special enrollment rights? And for the employer and employee costs, number 20, that would apply for several different things. Maybe documenting if the plan claims grandfather status, if there's been changes since 2010. Also, documenting affordability under the Affordable Care Act if you're a large employer. And one thing I want to mention is, even though it's really the IRS that has jurisdiction over affordability and the large employer mandate and the 4980H penalty, if you have an audit by the Department of Labor, if they find noncompliance or questionable issues, or especially if they find egregious violations, they will probably just go back to the office and turn over your, they'll let the IRS know, oh, here's a plan that appears to have not only DOL violations but also IRS violations. Or they could notify the state labor commissioner if there are issues. The other thing that happens is if you have an audit by a DOL auditor of your group health plan and they find a lot of violations, you're likely to get a letter from the DOL after that wanting to audit your retirement plan as well, because they'll just figure if you're doing that poor of a job on your group health plan, you might be doing just as poor a job on your 401k plan or your retirement plan. So it is good to be careful about those things and make sure you're in compliance even if it's not specifically a DOL issue. The next item on the DOL checklist is HIPAA documentation. And mainly they're looking for, they list all these things. Mainly they're looking at certificates of credible coverage when those were needed, which are no longer needed for most plans as of 2015. If you have a notice of pre-existing conditions exclusions, which again aren't an issue, aren't allowed anymore under the Affordable Care Act, but if you have a small insured plan that was allowed to renew as non-ACA compliant, then you may still have certificates of credible coverage and you may still have pre-existing conditions exclusions. So that, and it certainly is something that you'll need to have documented from prior years. And then the third thing under HIPAA would be the special enrollment rights. So this is, and if you change carriers, keep a file of what carriers you have and to whom you would contact for these items. Because if you've changed carriers in the last few years and then you have a DOL audit, if you need some of these things, you might get the bottom of the list on your prior carriers if you call a prior carrier. The other thing is on HIPAA privacy and security rules, those would not be covered under a DOL audit, but those are something that HHS and CMS would audit. It's still another thing you need to be in compliance with and document your compliance, but it's not something that the Department of Labor would be looking at or dinging you for on a DOL audit. The next part of the list from the Department of Labor. Plan rules regarding coverage of medical, surgical, and mental health benefits, Mental Health Parity and Addiction Equity Act requirements. Plans notices on newborn, rules on pre-authorization on hospital length of stay in connection with childbirth, the CHIP notice of the Children's Health Insurance Plan, list or logs of notices that you issued, the WIPWR records, Women's Health and Cancer Rights Act, your initial notice and your annual notice, and if you have a wellness program that meets certain requirements, they'll want to see materials describing it and making sure that you have the required statement about the availability of a reasonable alternative standard. So some of those, so you want to have those items in your file. Some of those are self-explanatory. Let me talk about two of them. The Mental Health and Parity and Addiction Equity Act basically says that the plan cannot provide less favorable coverage for mental health and substance use disorder benefits than it does for medical, hospital, or medical surgical benefits. That's if the plan does provide medical surgical benefits. It doesn't require the plan to, but I mean if the plan does provide mental health and substance use disorder benefits. So it doesn't require the plan to do that, but if it does, there has to be parity. And that's in annual and lifetime dollar limits and also in financial requirements and treatment limitations. If you have an insured plan, the insurance policy is probably in compliance. If you're self-insured, you might want to make sure that your policy is compliant. Check with your TPA or attorney. There were final regulations that went into effect July 1st, 2014. But that's something that the DOL is probably looking at. The other item on the wellness program, if you have a wellness program that has a penalty or reward for meeting specific outcomes, that can't exceed 30%, and if the reward affects the employee's cost of coverage under the group health plan, the reward or penalty can't exceed 30% of the cost of coverage. It used to be 20%. The Affordable Care Act increased it to 30%, and it's up to 50% for smoking cessation wellness programs. But the program does have to meet certain requirements, like the opportunity to qualify at least annually, and it has to be reasonably designed to promote health or prevent disease, and has to be available to all similarly situated individuals. And then the last thing is you have to notify participants of this reasonable alternative standard. So that's the thing the DOL is going to be looking for is, did you have the specific notice? So you'll want to have in your file documentation of what your wellness program requirements are and the reward or penalty amount if it's a percentage of the group health plan cost, and also notices of the reasonable alternative standard that basically just says if the participant can't meet the standards for medical reasons or their personal physician recommends that they not have to do that, that there are reasonable alternative standards available that the person can meet. So that's something you definitely want to document if you have a wellness program. Health risk assessments are often part of a wellness program. There's increased use of them. It's not really a DOL audit list issue, but just be aware that the EEOC has recently initiated several complaints or lawsuits, and they disagree with the criteria, some of the criteria that the DOL says are okay. And the issue is often when an employer says if the participants, if employees don't participate in the health risk assessment, that then they're going to have to pay 75% or all of the group health plan costs, or that they might be subject to disciplinary action. So that's an unfolding issue right now, but just be aware if you're using the health risk assessment. Okay, so the kind of last area on the DOL 4-page checklist is Affordable Care Act requirements. And they request documentation that, for example, in 2011, when children could enroll to age 26, if they were already you needed to send out a notice so that if people had children who had aged out, they were notified that they could re-enroll. And other requirements under the Affordable Care Act, if coverage has been rescinded, you need to have a list of people for whom coverage was rescinded, the notice of it, the reason for the rescission. For a lot of employers, that's not an issue. They haven't had anyone in that category. Also, there are lifetime and annual limits are prohibited or were phased out under the Affordable Care Act, so you need to show that you are in compliance with that. If your plan is claiming grandfather status or did claim it for some prior years, you need to be able to document that you met the grandfather requirements, and it has to be a disclosure statement and records documenting the terms of the plan. Leavitt and GPS, we do have a grandfather documentation kit, which probably for many of you, your advisor has already used if you are claiming grandfather status. And if the plan is not claiming grandfather status, then other Affordable Care Act requirements apply. A choice of provider notice, if there's a network and in-network and out-of-network, or payment of benefits for emergency services, coverage of preventive services not subject to the deductible, and claims and review procedures. And then the last thing is if you had any rebates, particularly like medical loss ratio rebates, you need to have documents showing how those rebates were distributed either to plan participants or if they were kept just by the plan sponsor. And then the last thing is any additional documents that the Department of Labor requests. And what they may do is look at the initial ones and then request more documents. So now that you've got all that stuff and you've been keeping a folder of it, what do you do if you do get a DOL audit letter? Well, just keep in mind two things. The purpose of the audit, they're going to look at whether the plan is compliant on its face and also in operation. So, and this is a quote from the DOL website. So they're requesting all those documents to see if it's in compliance on its face. And then they're also looking at in operation is the plan, are the plan fiduciaries and is the plan administrator actually providing the disclosure and actually providing the benefits in operation that should be provided. So let me say a couple things to watch out for, and I'll be talking about those. And I'm going to kind of go through quickly on the steps for the DOL audit because I'm really focusing here on being prepared for it in advance of it, but I'll quickly go over what the steps are. One thing is the ERISA 502L penalty, and I'll talk about that for breach of fiduciary duty, and that's at 20% of the amount involved. Also, if you did get MLR rebates in 2012 or 13 or 14, you definitely need to document how you decided to allocate to participants because I think that's you've got an 80 to 100% chance of being audited if you got MLR rebates because in the past when there were rebates when plans were demutualizing, the DOL audited every ERISA plan that got the rebates. Those were generally larger amounts, so they might get a list and then only audit the larger amounts. I don't know. If you're claiming grandfather status and weren't complying with some of the provisions that applied to non-grandfathered plans, I think that's likely to be something on audit. You'll have to, either you're more likely to be audited or on audit you'll have to provide that information. Also, the healthcare reform notices, keep a copy of the notices you sent and when they were sent, or if the carrier sent them, keep a copy of the notices. If you do have a wellness program where the rewards are, a penalty is a percentage of the group health plan cost, you want to have documentation of that, and for different years if that changed. Also, if you sent notices electronically, you want to be able to document that the people you sent them to were in that first category that I mentioned, and if they were in the second category, that you got written notice, written agreement from people beforehand to receive it electronically. If you do have self-insured plans and you have a trust, then you're likely to be asked about the amount of the assets that you have on reserve. So briefly on the DOL audit, the chronological steps, there's an initial letter from the Department of Labor. You provide those initial documents, and it could be by email. There's an on-site review. The DOL auditor can interview benefits people or people at your site. Then they either identify alleged ERISA violations, or they give you a letter that says no ERISA violations were found, or they give you a letter that says they were found. So if you do get the step one, if you do get that initial request, with recent requests, the DOL has had a very short time frame that they're asking for, like within 2 weeks to get documents. You can either, if that's too short a time frame, you should call them initially, partly just to establish the rapport and the time frame, but also if you can't get some of those documents right away because they're off-site in a box, or you have to call prior TPAs or carriers to get the information, let them know that. And they may say, don't send any of the information until you have all of it, or they might say, send us what you have, and then send the rest of it later. If you do have a service provider, like a third-party administrator, call them right away if you might need documents. Don't let it sit on your desk or someone else's desk for a few days and it turns into a week, and then call them. So do get that started right away. Notify your senior management. Talk with your legal counsel because you might need to get legal counsel involved. And if you need to finalize some documents, like if you're working on or thinking about a wrap document, then I'd say do it now when you first get the initial request. How can we help? We can provide any documents we have. We can request documents. We can help you get documents from carriers and TPAs. Also, one thing we'll probably ask you is, are you aware of any disgruntled former employees or incidents that might have resulted in a complaint to the Department of Labor? Because the DOL generally will not tell you why they're auditing you, whether it's just a random audit or whether they're responding to a complaint from someone in particular. But you may want to try to figure out why are they auditing me at this time. And so that would be a thing to think about, is there some area in particular that you think the DOL is auditing? And I'll talk about why in just a minute. We can also give you referrals to several different benefits attorneys if you don't have one that you want to use, or you can call and talk to several of them. If you did get the MLR rebate, use our worksheet if you haven't already. And that attachment A that I just went through, if you get that from the DOL, which you will if you're audited, use that as a checklist and then number the documents on the list and put either not applicable or have the documents. For step 2, the on-site review, the auditor is likely to request additional documents, but maybe not, and they may request the documents electronically. That's what they're doing a lot these days, or in the olden days, and maybe even now, put it in a 3-ring binder and put their letter on top, their attachment A on top, and then just provide those documents. Because you want to make it easy for them to look at the information, but don't provide additional information that they haven't asked for. But you don't want it to be difficult for the DOL auditor so that they get perturbed at having to do the audit, or they think that you're trying to hide something. And whatever the tip is, whatever you provide to them, keep your own folder with that also, either electronically, or if you do a 3-ring binder, you might want to make a copy for yourself, even though it's a lot of paperwork. Step 3, the interviews. The DOL auditor can interview the plan administrator, the benefits staff, the record keepers, fiduciaries, attorneys, accountants. They can subpoena people if they need to. So I think it's better to cooperate than refuse, but talk with your legal counsel. And particularly, there may be reasons that you want to make it more, you don't want to give some information if they ask about it. The person being interviewed has the right to have their attorney present, but they can't request other people. So if you're the benefits director and there's a benefits manager that they're going to interview, you cannot insist on being present when they interview your benefits manager. So you could have your attorney present, but you can't insist on it. And really discuss things with your legal counsel beforehand, because there may be issues that if there's something that you're going to, that going to be a problem, you want to fix it before the DOL asks about it. And then answer questions truthfully, but as I said, don't volunteer additional information. So if there are things that, if you talk with your legal counsel beforehand and you realize there are areas where there's an issue and it's going to have to be fixed, you can correct it or use the voluntary compliance program and not be subject to the 502L penalty. But if you correct it after the DOL has already told you about it, then you'll probably be subject to the 502L penalty. So if the DOL does an audit and finds problems or potential problems, they'll notify you first. Then the regional office issues a voluntary compliance letter, VC letter, listing the violations. And if you do get that letter, you definitely want to get your attorney involved and talk about what corrective action to take. And if you correct after receiving the voluntary compliance letter, there's this 502L penalty, which is 20% of the amount involved. But if you correct before you receive that letter, then you're not subject to that penalty. And it's 20% of the applicable recovery amount if there's a breach of fiduciary duty or knowing participation in a breach by another fiduciary. And again, discuss it with your legal counsel, because if you correct it before you get that voluntary compliance letter, you won't be subject to the 502L penalty. And you can petition, if you do get it, you can petition for a waiver, but you often will not get it waived. So it's better to fix that in the first place. Then they'll issue, if there are no violations, they'll issue a closing letter, and the closing letter says the investigation is complete and no ERISA violations were found. And you can say, you can frame it and hang it on your wall. The other, alternatively, however, they might issue a closing letter and they'll list violations and they want compliance. So they basically want full compliance and voluntary compliance and full cooperation for the things that they said you weren't in compliance with. And that might be if there was a benefit, if there were benefit disputes or reporting and disclosure issues. The disclosure is the notices you send to participants. Reporting is the filings with the government, like the 5500, or if there were bonding issues, if you should have had a bond and you didn't. If there's voluntary compliance, there's no civil lawsuit, there's no criminal prosecution, but there's a voluntary compliance settlement agreement, and that will include the 502L penalties. And also, then you have to send a notice to plan participants that the plan was found to be in violation of XYZ, and that's been resolved, remediated, and that if you had to pay a penalty or whatever. So you'd rather not have it get to that point where you have to then send a letter to your plan participants, but then you would get a closing letter from the Department of Labor that says, okay, you are now in compliance. The other thing, the other alternative, is if there were a closing and they found violations and you didn't comply, so then it would be an in-violation closure. And there's a closing letter, but then they might, for example, say, we're referring this to the IRS. Or they could refer it for litigation, and it's the Division of Field Operations in the Office of Enforcement. Although the Office of Enforcement could decide not to file a lawsuit, even if EBSA sends them the letter referring it for litigation, but you're hoping it doesn't get to that. I mean, you want to correct it before it gets to that. And in the worst case, there could be prosecution, there could be criminal prosecution, and the DOL could just not even attempt voluntary compliance. And that's unlikely, but if they basically just said, this is so egregious and you're not cooperating, or particularly for a pension retirement plan, if it would risk the plan assets, they can just not even bother to continue with you, and they can just send it for litigation. So again, just to reiterate, the DOL can assess a civil penalty, or it can launch a criminal investigation. And then, as you can see, there's a very small number of criminal investigations. In 2014, there were 365 criminal investigations, and 85 of those resulted in a guilty plea or conviction. And so those criminal investigations could result from the initial civil investigation. So how can we help you? We have that DOL audit prep flowchart, the steps to compliance that I had at the beginning. I think I've got another one here. Oh, guess not. We also have a DOL audit guide that includes the audit checklist. It includes a shorter version than the actual attachment A. We have a health plan compliance checklist that we use internally, but we can also give that to clients, and that includes more than just the DOL audit requirements. That includes other compliance requirements that, for example, the ones that the IRS has jurisdiction over, or Health and Human Services, the HIPAA requirements, and the privacy and security requirements. We also have a compliance calendar, which is on our healthreformupdates.com website, and we send that out annually to clients. We have sample ERISA and Affordable Care Act notices. We have, as I mentioned, the MLR documentation worksheet if you got a rebate, and we also have a grandfather status documentation. And here are some resources that are available at the DOL website. Their enforcement manual, the M1 packet, and the M1 includes the self-compliance tool, starting on page 12 of the packet. And there's a reporting and disclosure guide for employee benefit plans. And that's it. I've run a few minutes over, but we're 11:08. So let me see if I, have any questions. Let me just say this. We are at the end of the formal presentation, and so I know that I want to be mindful of people's time. If you want to stay, and I'll go through the questions that are here, and also if you have additional questions, you can send them in. Of course, one of the questions is, will attendees receive a copy of the presentation? And yes, as I said at the beginning, if you don't have a copy, please contact the Leavitt or GBS advisor who sent you the invitation to this, because I know they'll want to follow up with you. And we have the presentation available on our internal website, and we'll send it out. Also, anyone who registered, even for this webinar, even if they didn't attend, the system will probably send out a notice with a link to the recording of this. We also record the webinars and turn it into a YouTube video, and we'll have the link to the YouTube video, because a lot of people have technical problems accessing the recording that the GoToWebinar system sends out. So, but it takes us a day or two to transfer it into a YouTube video, but we'll be sending out that link as well. Someone asked, are the requirements the same for retirement plans also? Generally, yes, but there are some different requirements that apply specifically for retirement plans, but some of the ERISA requirements apply for all plans. There's a different attachment A list that the DOL sends if they're auditing a retirement plan rather than a health and welfare plan. Let's see, someone asked, maybe call us afterwards. We are exempt from some of the DOL requirements due to our industry, but not sure if we are exempt from the specific requirements that fall under benefit programs and ERISA. Probably give me a call on that afterwards, or contact your Leavitt or GBS advisor. County government not subject to ERISA, will this webinar be pertinent to us? If you're a county government, as I said at the beginning, if you're a governmental entity that's not subject to ERISA, or church plan or tribal, then you would not have a DOL audit, but you would be subject to the Public Health Service Act, and that has a lot of the same requirements. Remember I said that the ERISA, a lot of the HIPAA and COBRA and Affordable Care Act requirements amend the Affordable Care Act, amend the Public Health Service Act as well. So even though the DOL wouldn't audit, you might be subject to an IRS audit, and they would be inquiring about many of the same documents that are in this, but also they could audit other areas as well. Like, for example, the large employer mandate 4980H A and B penalties are under the IRS jurisdiction. Next is the SPD required for fully insured plans. Yes, it is if they're an ERISA plan. If it's an employer who's subject to ERISA, like a private sector, for-profit or not-for-profit employer who's subject to ERISA, an insured plan, the insurance policy itself and the insurer are subject to state insurance commissioner and subject to the Public Health Service Act, so many of the same requirements, but the plan sponsor is subject to ERISA and the Department of Labor. So part of the ERISA requirements are reporting and disclosure includes the requirement to send the SPD. So even for a fully insured plan, the SPD requirements apply. Often, as I said, there's a lot of overlap between the summary plan description and the benefits booklet from the carrier. But there also might be, and a lot of times the carriers will include some of the ERISA requirements, the SPD requirements, like the ERISA rights page. But the thing that often the benefits booklet doesn't include is the eligibility provision. Often they'll just say eligibility is as determined by the employer. So you need something that also specifies eligibility, or how the plan can be amended or terminated, or who the named fiduciaries are. Or so some of that information is not in the benefits booklet, and an SPD is required even for fully insured plans. Let's see. And you should, yes, you should receive a link where the presentation can be downloaded, and that should come tomorrow from the system, or you could contact your Leavitt or GBS advisor today, and they can send you a PDF of the document. If you also wanted a link to the recording, that won't be available probably until tomorrow. Let me see. And then someone else asked, we fall under the Department of Transportation as a service provider performing services related to safety. Are we exempt from ERISA? I don't know off the top of my head. It sounds like you might not be as a service provider, because if you're not a government entity, but maybe give me a call afterward or contact your Leavitt or GBS advisor and we can talk about that. Okay, that is the end of the questions I have so far. If you have additional questions, please send an email or give us a call. And thank you again. I know this has been a long seminar and full of a lot of detailed information. I hope you can use the checklist. And again, we will be sending out our DOL audit guide and our five steps to compliance. And I know that for a lot of people, again, that was part of their one of their New Year's resolutions was to make sure their health plans are in compliance. So we're here to help you with that this year. Okay, thank you. And that's the end.